Hey guys, in this video, we're going to talk about what happens next after the I-130 has been approved. If you're overseas and you're waiting on this process, it could be very frustrating, especially if you don't know what to expect next. Or if you're here in the United States, you might be wondering, well, how do I actually get the green card in my hands, right? Can I do adjustment of status? I'm going to cover those issues in this video, so stay tuned. For those of you who are new to me, welcome to my channel. I'm Latoya McBean Pompey. I'm an immigration lawyer in New York, working with clients all over the world on complex family and business immigration matters. Reach out to us at McBean Law so that we could look at your situation. We can be reached at 516-866-3900, or you may book your appointment with our office at McBeanLaw.com. Also, before you leave today, don't forget to subscribe to my channel and hit the notification bell. Show your support for the work that I'm doing by hitting that notification bell so that you'll be the first to get notice of my videos each week. Now let's talk about the I-130 process. The I-130 is the underlying family petition filed by individuals who are filing for a spouse, parent, child, or sibling. Let's talk about those of you outside of America first. The question you need to ask yourself is my priority date current? Is it my turn? Has my turn come up yet for me to take further actions with this case? That's really critical, because if your priority date is not current yet, you really can't do much of anything right now. Once your case has been approved, the USCIS will send the case over to the National Visa Center, the NVC. The NVC does what it calls a case creation notification or letter. It will send you a letter or an email notifying you that they have your case, and there are some additional steps that you need to take in order to move the process forward. However, that case creation email or letter can be very confusing, because for many people, they actually can't do anything else right now. They actually have to wait because their priority date is not current yet. They're just being notified that the NVC has their case, and that system online, the application process, that system is not opened up to you yet. You can't even pay your fees or anything, not until it's your turn. Your priority date has to come up first. If your priority date is not current, you'll have to wait for the NVC to send you a second notification that it is now time to move forward with your visa application. If your priority date is current, oh, happy day, right? You can move forward and get things going at the NVC level. What happens if you're here in the United States? Should you apply for adjustment of status or not? Well, firstly, are you eligible to adjust your status, right? The big part that you need to really consider is this: am I an immediate relative of a US citizen, or am I in the family preference category F1, F2, F3, or F4? Where am I? Because if you're an immediate relative of a US citizen, you may proceed now and apply for adjustment of status. And in fact, if you are an immediate relative, you should have filed the I-130 and I-45 applications together. It's much faster and easier to do it that way. But in any event, if you're an immediate relative, you can go ahead and proceed with adjustment of status if you're eligible for adjustment of status. If you're in the family preference category, in a family preference category, have I continuously maintained a lawful status in the United States all this time? If yes, then you move on to the next question, which is my priority date current? If your priority date is current and you've continuously maintained a lawful status, then you may proceed and apply for adjustment of status. But if your priority date is not current and you had continuously maintained a lawful status, you have to continue to wait. until your priority date becomes current. What happens if you had not continuously maintained a lawful status? You will not be able to apply for adjustment of status. What happens next is this, guys. Again, you're going to go back to the question about whether your priority date is current. If it is current, then you're going to have to wait until your case goes over to the NVC and for them to notify you that they have your case. And then you're going to have to file a waiver, the I-601A waiver, which you guys have heard me talk about many times. You'll need that waiver, but you cannot file that waiver too soon. If you file it too soon, guys, before your case goes over to the NVC, that waiver application can be rejected by USCIS, and they'll send everything back to you because it's not your turn yet to apply for that waiver. So your priority date must be current in order to apply for that waiver. Again, this is only for those of you with an approved I-130. I'm not speaking about any humanitarian petitions or applications. Those come with different exemptions and opportunities than the I-130 family process, okay? So I'm only speaking about the I-130 process in this one. The issue with the waiver can be a little tricky and confusing, so I'm going to summarize that point for you one more time. If you're here in the United States and you had not continuously maintained a lawful status and your priority date is current, and your case is at the NVC level, then you may file the I-601A waiver, okay? But if your priority date is not yet current and your case is not at the NVC level, you still have to wait before you can file that waiver. I hope this video was helpful to you. Comment below, let me know your thoughts on this. And if you find yourself in one of those categories where you do need the waiver, reach out to us so that we could take a look at whether you're eligible for this waiver. Thanks so much for watching this video. Share it with other people, and I will see you in the next one. Bye-bye.